California's implied consent law, is found in Vehicle Code 23612. The idea is straightforward. By choosing to drive on California roads, you have already agreed in advance to submit to a chemical test of your breath or blood if you are lawfully arrested for DUI. You never signed anything. The consent is implied by the act of holding a driver's license and using public roads. Here is where most people get tripped up. Implied consent applies only to the evidentiary chemical test after a lawful arrest. It does not cover the investigation before the arrest. The handheld roadside breath device, called the preliminary alcohol screening test or PASS, and the field sobriety tests are generally part of that pre-arrest investigation. For most adult drivers, those are optional. Confusing the optional roadside test with the mandatory post-arrest test is the single most common misunderstanding in DUI cases. A refusal is not only someone saying no out loud. Staying silent, giving conditional answers, asking to speak to a lawyer before testing, or repeatedly failing to deliver a complete breath sample can all be treated as a refusal under the law. That said, genuine confusion, a language barrier, or a medical inability to complete the test is not always a legal refusal, and that distinction is often where these cases turn. Refusing the post-arrest chemical test starts consequences that are separate from, and on top of, any DUI charge. On the DMV side, a first refusal triggers a 1-year license suspension that generally does not allow the early restricted license many first-offense drivers can get. On the criminal side, a refusal adds a sentencing enhancement if you are convicted, and the prosecutor can point to your refusal in court as evidence of a guilty mind. And here is the practical reality. Officers can often get a warrant electronically within minutes and draw your blood anyway, so a refusal can produce both a blood result and a refusal enhancement at the same time. Implied consent is not a magic phrase that automatically validates whatever follows. The arrest itself must be lawful, and the officer is required to give you a specific admonition, that you must submit to a test, that you have a choice of breath or blood, and that refusing will cost you your license and add penalties. When that admonition is skipped, given incorrectly, or delivered to someone who genuinely could not understand it, the refusal allegation can fall apart entirely. Whether or not a refusal is involved, a DUI arrest starts a 10-day clock to demand a DMV hearing in order to protect your license. That deadline does not pause while you sort things out. Missing it generally means the suspension takes effect automatically. If a refusal allegation is part of your situation, this deadline is one of the first things to address. Understanding implied consent before you ever get stopped is far more useful than learning it from an officer reading off a card. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at dui.guru.